Hello students, welcome to the lecture on Law of Sales of Goods. After this lecture, you will be able to learn the following objectives. Explain the formation of contract of sale, discuss goods and their classification, explain the price, conditions and warranties, define passing of property in goods, describe the performance of contract of sale, explain the unpaid seller, sale by auction. Now let us know more about the sales of goods.
Of goods between a supplier and the customer.
It means that all goods sold have to require being of a satisfactory quality and fit for purpose.
This means the product or goods have to meet the standard purpose in the product's description, as well as personal purpose, for example selling a particular brand of shoes to an athlete.
It also refers to the selling of a good being sold to a consumer at a consideration called price.
Price of goods sold must satisfy both the supplier and the customer, therefore an agreement needs to be made.
Goods that automatically fall under this act are all tangible items that can be handled by both the supplier and consumer.
Therefore, if goods fail to meet the requirements presented on the packaging, etc., customers are entitled to claim under the Goods of Sales Act.
In trade and commerce, sales and purchase of goods are very common transactions. These transactions may appear to be very simple, but the possibilities of complications are always there. The Sale of Goods Act contains the basic principles as well as the legal framework of transactions of sale and purchase. This act extends to the whole of India except the state of Jammu and Kashmir. Buyer. Buyer means a person who buys or agrees to buy the goods. Seller. Seller means a person who sells or agrees to sell the goods. Delivery. Delivery means voluntary transfer of the possession of goods from one person to another. Usually, the goods are delivered from the seller to the buyer. Immediate delivery of goods is not necessary or mandatory. Price. Price means the money consideration for the sale of goods. The money here means the currency in circulation. Remember, any contract without consideration is usually not valid. Goods. Goods means every kind of movable property other than actionable claims and money, and includes stock and shares, growing crops, grass and things attached to or forming a part of the land which are agreed to be severed before the sale or under the contract of sale. Agreement to sell, where the transfer of property in goods takes place at a future date. Sale, when the transfer of property in goods takes place at the time of contract. Document of title. The document of title of goods includes the following documents: the bill of lading, the dock warrant, the warehouse keeper's certificate, the wharfinger's certificate, the railway receipt, the multimodal transport document, the warrant property. Property. Property means the general property in goods. The property can be understood in two ways with reference to any goods. The general property in goods means ownership. The special property means the possession or control of goods. Formation of contract of sale. The essentials of a contract of sale are as under. Two parties. There must be two parties. One cannot sell to himself. The seller and the buyer must be different. A part owner can sell goods to another part owner. Goods. The subject matter of the contract of sale is goods. The goods must be movable. Immovable things are out of the purview of the act. The goods may be present or future. Transfer of property. The seller transfers or agrees to transfer the property in goods. The transfer of property in goods means the transfer of general property. Consideration. The price is the consideration for the contract of sale of goods. The exchange of goods for goods is barter. Exchange is partly for goods and partly for money in a sale. Elements of contract. All essential elements of a valid contract must be observed because basically it is contract. Form of contract of sale. No form of contract of sale is prescribed under the Sales of Goods Act. The contract of sale can be expressed or implied. The contract of sale may be in writing or by word of mouth. The contract of sale can be conditional or absolute. Delivery of goods. The contract of sale may provide any of the following methods for the delivery of goods. Immediate delivery of goods. Immediate payment of price but delivery at some future date. Immediate payment of price and immediate delivery of goods. Delivery or payment or both made in installments. Delivery or payment or both will be made at future date. Contract for work and skill. Following are the main features of contract for work and skill. The main purpose of a contract is to exercise work and skill. The supply of own goods is only subsidiary or supportive. The intention of the parties is to transfer goods only after the exercise of some skill and labor. The Sales of Goods Act is not applicable to this category of transaction. Goods and their classification. The goods forming the subject matter of the contract of sale may be classified as under existing goods. The existing goods are the goods which are owned and possessed by the seller at the time of sale. The existing goods may be of three types. Specific goods. The goods which are identified and agreed upon by the parties at the time of the contract of sale are specific goods. 2. Ascertained goods. Ascertained goods are the goods which are identified after the formation of the contract of sale. When the unascertained goods are identified and agreed upon by the parties, the goods are called as ascertained goods. 3. Unascertained goods. These are the goods which are not identified and agreed upon at the time of the contract of sale. These goods are merely described by the parties at the time of the contract of sale. Future goods. Future goods are those goods which do not exist at the time of the contract of sale. These goods are to be manufactured or acquired by the seller after the making of the contract of sale. Contingent goods. It is a kind of future goods. These goods are those goods the acquisition of which is contingent upon the happening or non-happening of an uncertain event. Price of goods. Following are the methods to determine the price. Method 1. The price is specified under the contract. It is the most common method of determining the price. Here, the parties decide the price in advance. Method 2. The price may be determined as per the method specified in the contract. Here, the parties decide in advance the method of determining the price. Method 3. The price may be determined in accordance to the custom and the usage of the trade. This method is applicable if the parties regularly trade. Where the price is not fixed as above, the buyer shall pay the seller a reasonable price. Method 4. The price may be determined by the third party. If it is so, the contract shall specify the name of the third party. If the third party fails to specify, the contract is void. But if the goods are delivered to the buyer and used by him, he is required to pay a reasonable price. Consequences of destruction of specific goods. The consequences of the destruction of specific goods can be discussed under the following three heads. If goods perish before making of contract, it is to be noted that if the seller has knowledge about the destruction of goods, even then he enters into the contract of sale with the buyer, then the seller is bound to compensate to the buyer. When a part of the goods is perished before making contract, if the goods were divisible, then the contract can be enforced partly, and if the goods were indivisible, then the contract becomes void ab initio. If goods perish after the agreement to sell, but before sale, the contract is void if subsequently the goods have perished and there is no fault on the part of the buyer or the seller in perishing the goods. Rules regarding delivery of goods. The rules regarding the delivery of the goods are contained in section 32 to 39 of the Sales of Goods Act, which may be discussed as under. Payment of price. The general rule suggests that the delivery of the goods and the payment of the price are concurrent conditions. It means if the contract of sale provides that the payment will be made in future or the payment will be made in installments, it is a valid contract. Buyer's duty to demand goods. It is the seller's duty to be ready and willing to deliver the goods to the buyer, but he is not bound to deliver the goods unless the buyer makes a demand for the delivery of the goods. If the buyer fails to demand the delivery of goods, the seller is not liable for breach. The buyer must demand the delivery within a reasonable time. Types or mode of delivery. Actual delivery. It is the delivery where the goods are handed over to the buyer or his authorized agent. It means the goods are physically put in possession of the buyer. Symbolic delivery. When the goods are not physically delivered to the buyer, but some symbol of the real possession or control over the goods is handed over to the buyer. The symbolic delivery of goods is also known as atonement. The transfer of documents of title to the goods, that is, the railway receipts, bill of lading, delivery orders are instances of symbolic delivery. Constructive delivery. When the third party who is in possession of goods acknowledges holding the goods on behalf of the buyer is known as constructive delivery. Time of delivery. If the contract specifies the time of delivery, the goods shall be delivered within such time. If no time is specified in the contract as to the time of the delivery of goods, it should be delivered within a reasonable time. Expenses. All the expenses of making the delivery of goods shall be paid by the seller unless otherwise agreed, and all the expenses of receiving the goods are paid by the buyer. However, the seller and the buyer may agree otherwise. Delivery of wrong quantity. If the seller has delivered excess quantity, the buyer has the following options: to accept the whole of the goods delivered to him, to reject the whole of the goods delivered to him, to accept the contracted quantity and reject the excess. If the seller has delivered a short quantity, the buyer has the following options: to accept the goods delivered to him, to reject the whole quantity delivered to him. Delivery of mixed quality quantity. The seller is bound to deliver the goods of exact quality quantity. Otherwise, the buyer may reject the whole, reject the goods not complying with the quality or quantity, and accept the rest. Delivery by installment. The buyer is not bound to accept the goods delivered in installment. The delivery by installment is not valid except if the contract provides so or the buyer accepts the delivery in installment. Right to examine. In every contract for sale of goods, the buyer has the right to examine the goods unless otherwise agreed in the contract. Delivery to carrier or wharfinger. The delivery to the carrier or the wharfinger amounts as the delivery to the buyer if the following conditions satisfy: the buyer has made a reasonable contract with the carrier, the seller is required to give notice to the buyer to enable him to insure the goods. Goods sent by sea route. Where the goods are sent by the sea route, the seller shall give a notice to the buyer to insure the goods. Otherwise, he will be liable for a loss. Price, conditions and warranties. Generally, at the time of sale, the seller makes some representations, statements, or stipulations for the praise of his goods. Some of the representations are in nature of opinion, while others are in nature of facts. The representation as to the fact which becomes a part of the contract of sale is called as stipulation. The stipulation may be a condition or warranty depending upon its importance in relation to the contract. The stipulation which is essential to the main purpose of a contract is known as condition. The stipulation which is collateral to the main purpose of the contract is warranty. The breach of condition in a contract of sale of goods gives right to cancel the contract. If the party has suffered from any loss, he can also claim compensation for the breach of condition. However, the liability for the implied conditions and warranties may be excluded by the parties in the following situations. If an express agreement between the parties provides so, if the course of dealings between the parties suggests so, if there is a custom or usage of a particular trade. According to the Section 13 of the Sale of Goods Act 1930, a breach of condition may be treated as a breach of warranty in the following circumstances. Where a contract of sale is subject to any condition to be fulfilled by the seller, the buyer may waive the condition. Where the buyer elects to treat the breach of condition as the breach of a warranty. Where the fulfillment of any condition or warranty is excused by law by the reason of impossibility or otherwise. Implied conditions, conditions as to title. There is an implied condition on the part of the seller that, in the case of a sale, the seller has a right to sell the goods. In the agreement to sell, the seller will have a right to sell the goods at the time of passing of the ownership in goods. Conditions as to description. Where the goods are sold by description, if later on the buyer finds that the goods are not as per description, he may reject the goods and claim a refund of the price. Sale by sample. Where the goods are sold by the sample, following are the implied conditions. The bulk shall correspond to the sample in quality. The buyer shall be given a reasonable opportunity to compare the goods with the sample. The goods shall be free from any defect, rendering them unmerchantable. It is to be noted that the implied condition applies only in the case of the latent defects, that is, those defects which cannot be discovered by ordinary inspection. Implied warranties. Following are the implied warranties. Warranty as to quiet possession. In the absence to any contract showing a contrary intention, there is an implied warranty that the buyer shall have and enjoy the quiet possession of the goods. If the buyer is disturbed in the enjoyment of the goods, he can claim the damages from the seller. Warranty against encumbrances. Unless the circumstances of the case are such as to show a contrary intention, there is an implied warranty that the goods shall be free from any charge or encumbrance in favor of any party not declared to the buyer before or at the time contract is made. Warranty as to quality and fitness by usage of trade. An implied warranty as to the quality or fitness for a particular purpose may be annexed by the usage of trade. Warranty to disclose the dangerous nature of goods. In case of the sale of dangerous goods, the seller is under an obligation to warn the buyer about the probable danger. A failure to do so will make the seller liable to pay the damages. Doctrine of caveat emptor. Caveat emptors is a Latin word. It means let the buyer beware. It is the buyer's duty to select the goods of his requirement, and the seller is not bound to supply the goods which shall be fit for any particular purpose of the buyer. It suggests that the buyer, while purchasing the goods, must act with a third eye and ear. He should be careful to see that the goods purchased will serve his purpose well. If the buyer is not careful and he finds later on that the goods do not serve his purpose, he cannot hold the seller liable for it. The seller is under no obligation to tell the defects of his articles. Passing of property in goods. The main purpose of a contract of sale of goods is to transfer property, ownership in the goods from the seller to the buyer. The parties to a contract of sale of goods are subject to certain rules, free to agree terms as to the transfer of property and of risk. It is important to remember that ownership and possession are two different things. Sometimes the transfer of ownership in the goods will occur at the same time as their physical delivery, but this is not necessary. A seller might therefore still have physical possession of the goods even though property in them has passed to the buyer, or deliver the goods to the buyer yet still retain property in them. Transfer of ownership of specific goods. Ownership is transferred at the time of making contract. The ownership is transferred immediately at the time of making the contract if all the following conditions are satisfied. The contract is for the specific goods. The goods are in deliverable state. The goods are not required to be weighed or measured for determining price. Ownership is transferred when goods are put in deliverable state. If the goods are not ready in the deliverable state at the time of making the contract of sale, the ownership of goods is transferred after the formation of the contract of sale when the following conditions are satisfied. The contract is for specific goods. The goods are put in deliverable state by the seller. The fact that the goods are put into a deliverable state has come to the knowledge of the buyer. Transfer of ownership in the case of unascertained goods. In the case of the unascertained goods, when both the parties came to know which particular goods shall be delivered, the ownership is transferred. Following conditions must be satisfied to transfer the ownership. Ascertainment is the first step in the transfer of ownership. It means the process of identification and setting aside of the goods from a huge mass of goods. Generally, it is made by the seller, unilateral act. The contract to sell unascertained goods is not a complete sale. It is the agreement to sell. Unpaid seller. The seller to whom the full price of the goods sold has not been paid is known as an unpaid seller. A seller of goods is deemed to be unpaid in the following cases. The price must be due but not paid. A negotiable instrument like check, bill of exchange, etc. was received, but the same has been dishonored. When the seller has been paid a large amount, but small portion of the payment remains to be paid. When the price has been paid, but some other expenses which were payable to the seller have not been paid. The seller must have an immediate right of action for the price. Rights of unpaid seller. Rights of unpaid seller against the goods when ownership is transferred. When the ownership of the goods is transferred, the seller has the following rights available to him based upon the circumstances which can be discussed as under. The right of line. Option. The right of lien. The right of stoppage in transit. The right to the resale of goods. Rights of unpaid seller against the goods when ownership is not transferred. When the ownership is not transferred to the buyer, the seller has the right to withhold the delivery of goods. In case where the ownership is not transferred to the buyer, the seller has no other right available to him. Rights of unpaid seller against buyer. An unpaid seller has the following rights available against the defaulting buyer. He may sue for the price. He may sue for the damages for the non-acceptance of goods. He may sue for the damages for the repudiation of the contract before the due date of the delivery of goods. He has the right of interest for the delayed payment. He may sue the damages for the wrongful refusal to take the delivery. Seller right. Right of lien. Lien means the right to retain the possession of goods until the full price is received. The right of lien can be exercised on the goods. The seller can exercise his right of lien on the following two conditions. He must be in possession of the goods. He is an unpaid seller. In the following circumstances, the unpaid seller's lien is lost. When the seller waives his right of lien, when the buyer disposes of the goods by sale with the consent of the seller, when the goods are delivered to the buyer or his agent, when the price is paid by the buyer, when the goods are destroyed. The right of lien cannot be exercised in an independent capacity. The goods are deemed to be in course of transit from the time they are delivered to a carrier for the purpose of transmission to the buyer until the buyer or his agent takes their delivery. The goods are in transit even if the buyer asks the carrier to take them to some other destination until they are delivered to the buyer at some other destination. If the goods are rejected by the buyer and the goods are in the possession of the carrier, the transit is not at an end even if the seller has also refused to take them back. Right of resale. If the ownership of the goods is transferred to the buyer but the price is not paid and the goods are in possession of the seller, he can exercise the right of resale. In case of perishable goods, the unpaid seller can resale the goods if the buyer fails to pay the price within a reasonable time. The seller is not required to give notice of the resale in the case of perishable goods. In case of the non-perishable goods, the unpaid seller can resell the goods if he has exercised his right of lien or stoppage of goods in transit. Right to withhold delivery of goods. The right to withhold the delivery of goods means the seller refuses to deliver the goods to the buyer. The following conditions must be satisfied to exercise the right to withhold the delivery of goods. The seller is an unpaid seller. The ownership of goods has not been passed. Delivery to carrier. A carrier means a transporter or a bale to which the goods are delivered by the seller for transportation to the buyer. When the goods are delivered to a carrier, it is deemed delivery of goods to the buyer if the following conditions are satisfied. The seller delivers exactly the same goods as per the contract. The buyer has informed the carrier name, address, and the goods required to be delivered. The seller delivers the goods for the purpose of delivery. Buyer's right against the seller or remedies against seller. The buyer has the following remedies against the seller. Suit of damage for non-delivery. The buyer is ready and willing to take the delivery of goods, but the seller wrongfully neglects or refuses the delivery of goods. The buyer may sue the seller for the damage for non-delivery. Suit for specific performance. When the seller's wrongful refusal to deliver specific or ascertained goods is seen, the court may direct a specific performance order. Suit for breach of warranty. If there is breach of warranty, the buyer may claim the damages from the seller. The buyer may recover the damages if the price is paid. Right to repudiate the contract. If the seller declares his intention of the non-delivery of goods, the buyer may repudiate the contract and immediately sue for damages. Suit for interest. In the absence of any contract to the contrary, no interest shall be payable by the buyer on the delay payment. If there is no such agreement, the seller may give notice to the buyer of his intention to charge interest on the delayed payment. Sale by non-owners or transfer of title by non-owners. The general rule is expressed by the maxim nemo dat quod non habet, which means no one can give what he does not himself possess. Following are exception to the above general rule. Sale by mercantile agent. The agent of the seller can transfer the title if the following conditions are satisfied. The agent must be in possession of the goods or document of title. The agent has sold the goods in ordinary course of business. The buyer has acted in good faith. The buyer has no knowledge that the seller had no authority to sell. Sale by one of the joint owners. One of the joint owners can sell the goods if the following conditions are satisfied. The goods are in sole possession of one of the joint owners. The buyer has acted in good faith. The buyer has no knowledge that the seller had no authority to sell. Sale by person in possession under voidable contract. The seller must be in possession of the goods under the contract voidable. The goods must have been sold before the contract is rescinded. Option: before the contract is rescinded. The buyer has acted in good faith. The buyer has no knowledge that the seller had no authority to sell. Sale by seller in possession after sale. The seller may sell the goods in possession after sale if the following conditions are satisfied. The ownership of goods has been passed to the buyer. The seller continues to be in possession of the goods even after sale. The seller resells the goods to a new buyer. The new buyer buys without any notice to prior sell. Sale by unpaid seller. This is the sale by the unpaid seller after the exercise of his right of lien or the right of stoppage of goods in transit. Sale by liquidator. If the owner of the goods has declared insolvent and his goods are sold by the official receiver or assignee or liquidator, the liquidator has the authority to sell the goods as per the court order. Sale by finder of goods. If the owner cannot be found or found but refuses to pay the lawful charges to the finder, the finder of goods can sell the goods when the goods are perishable in nature or in danger without finding the true owner of goods to save the goods from loss. The finder of the goods can sell the goods if the lawful charges of the finder amount as 2/3 of its original value. Sale by pawnee or pledge. If there is a default on the part of payment of price or performance within time after serving the notice of the reasonable time, the pawnee or pledge can sell the goods in public auction to recover his due. Sale by auction. It means public sale. The seller invites the interested parties by advertisement to offer the price that is bid. The seller may hire the service of the auctioneer. An auctioneer is an agent of the seller. The advertisement of the auction sale is not an offer but an invitation to make an offer, and therefore, if an auction sale is not held on the appointed day, the bidder cannot sue the auctioneer. Every bid amounts as an offer and the acceptance is given by the auctioneer by some usual mode of acceptance. Example, fall of hammer. The auction sale starts with the placing of bids. The auctioneer accepts the highest bids, but he may accept the lower bid without giving reason. When the bid is accepted, a valid contract is formed. Delivery of goods in contract by sea route. It includes the following 3 categories of contracts. CIF contract. It means cost, insurance and freight. Here the price of goods includes the cost of goods, insurance and freight expenses. In the CIF contract, the buyer pays the insurance and freight expenses. The essential of the CIF contract is that the seller shall deliver the shipping documents to the buyer, usually through the bank. If the seller fails to deliver the documents within a reasonable time, he is liable for breach of contract. FOB contract. It means free on board. Here, the seller is required to put the goods on the board of ship at his expenses. The buyer is liable for all the expenses and risk once goods are loaded on the ship. Ex-ship contract. It means the contract in which the seller has to deliver the goods to the buyer at the port of destination. All the freight charges and risks during the voyage for the goods remain with the seller. Summary. Now in the end, let us summarize what we have learnt in this lecture. The Sale of Goods Act contains the basic principles as well as the legal framework of transactions of sale and purchase. The general property in goods means ownership, while the special property means the possession or control of goods. Sometimes the risk is based upon the custom or the usage of trade, where the delivery of the goods has been delayed due to the fault of buyer. The seller, to whom the full price of the goods sold has not been paid the price, is known as an unpaid seller. A carrier means a transporter or a bale to which the goods are delivered by the seller for transportation to the buyer.